What sets modern history apart from the ages of prehistory is that our history is written. Our progress through time, our achievements and milestones are recorded for posterity. The Hammurabi Code, the Ten Commandments, the Bible, the Quran, these are all written records of laws we live by. American democracy, too, has a lineage of written records that we can trace and show the development of our nation. Each document builds on those before it to make our foundation of history stronger. This is Documents of Destiny, Growth of a New Nation. In our program, we have 4 subject matter experts. Priscilla Zotti, Associate Professor of Political Science, United States Naval Academy, Annapolis, Maryland.
From 1801 to 1864, those 63 years, there were 15 presidents of the United States, but only 2 Chief Justices of the United States. And Marshall's impact of the 34 years that he is chief is undeniably shapes the development of the country.
Michael Sugrue, Research Fellow, the James Madison Program in American Ideals and Values, Princeton University.
America was organized around the idea that we would have democracy, but strangely enough, the Constitution makes no mention of political parties. Partisanship was thought of as being an evil thing, the precursor to civil war.
Robert George, McCormick Professor of Jurisprudence and Director of the James Madison Program, Princeton University.
After our successful rebellion against Britain and the establishment of the United States as an independent country, we went through a long period of controversies involving several European countries, and most notably Britain, of course, and also France.
Kent Neumeyer, Emeritus Professor of History, University of Connecticut.
There were a group of Americans ultimately led by Thomas Jefferson and ultimately turned into a political party, the Democratic Republicans, who thought the French Revolution was in the tradition of the American Revolution and embodied the realization of liberty. So there was this huge conflict over the meaning of the French Revolution. And that was a sort of defining ideological moment, I'd say, of the 1790s.
By the end of the 1700s, the United States of America was a fledgling democracy whose foundation was challenged by conflicts within and outside the United States. War between Britain and France was disrupting U.S. trade, and Americans were divided over our policy of neutrality. The Alien and Sedition Acts grew out of this conflict. But first, some background.
The central event, the defining event probably of that 1790s decade was the French Revolution. And what happened, of course, is Americans divided very sharply over the French Revolution. The analogy might almost be, analogies are dangerous in history, but I would say it might even be to the Cold War.
The international context is important. We're at the time engaged in a quasi-war with France, a series of naval encounters, and a collection of hostile naval encounters with England off and on as well. More important is the domestic context.
The political climate at the end of the century was such that many individuals more identified with their state than they did with the national government. And this created a sense of sectionalism, which really is the precursor to the political parties.
In 1796, George Washington's decision not to run for a third term cleared the way for America's first two-party election. The Federalist Party ticket of John Adams and Thomas Pinckney faced off against Democratic Republicans Thomas Jefferson and Aaron Burr.
Washington, of course, attempted in 1793 to maintain neutrality. His famous April resolution, 1793, that we should maintain a kind of neutral relationships between France and England. And this was the policy which also John Adams attempted to carry out. But Adams was a moderate, and there were people in his own party, Alexander Hamilton, Timothy Pickering in particular, who wanted to push the policies of the Adams Federalists in the direction of a so pro-English, commercial, anti-French policy. So it was an inter-party struggle as well as a struggle between the Federalist Party as it was taking shape and the Democratic Republicans led by Thomas Jefferson.
Many individuals felt very strongly about their state and were very much proponents of states' rights, and this really became a political party led by individuals such as Thomas Jefferson. On the other side, there were individuals that felt the most important thing for the nation to grow and develop, to have commerce and trade around the world, was a sense of nationalism, and this became the precursor to the Federalist Party.
John Adams won the election and became the second president of the United States. And because of a loophole in the electoral process, Thomas Jefferson became vice president.
The way in which the ballots worked before the 12th Amendment is written is that the top vote getter became the president, the second vote getter became the vice president, and before political parties developed, there was no sense that this would be a problem.
In 1798, the United States faced its first constitutional crisis when the Federalist-controlled U.S. Congress passed the Alien and Sedition Acts.
So what they proposed to do was insulate certain figures in the federal government from the more scurrilous and excessive criticism, particularly on the part of popular writers and newspaper editorialists. So what they did was, in 1798, was pass a series of laws, first of all, giving the president the right to expel from the country those aliens who were, in time of war, potentially a threat to the government. Second of all, it gave the president the right to prosecute critics for seditious libel.
The Alien and Sedition Acts were a series of 4 laws enacted not only to protect America, but also designed to weaken and eventually destroy the Democratic Republican Party.
Ultimately, the Alien and Sedition Acts were an effort on the part of the Federalist Party to put the political opposition out of business. That was basically what they intended to do. I mean, they did so by making it a crime punishable by fine and imprisonment for criticizing the government. Bringing the government into disrepute was a crime.
The Alien Act targeted foreigners. It gave the president power to imprison or expel all such aliens as he shall judge dangerous to the peace and safety of the United States.
And what we're talking about here is really the French, also maybe the Irish, because the Federalists felt that the French and the Irish, who were immigrating this country in the 1790s, always joined the radical, Democratic Republicans. So, hey, get these guys out of business. The main one of the Alien Acts was the one that extended naturalization from 5 years to 14 years.
The Alien and Sedition Acts were an attempt to limit the scope of legitimate criticism of the government. And what it meant is that they haven't fully worked out the idea of a loyal opposition, a very sophisticated and important idea.
Clearly, these acts run contrary to the spirit of freedom that America was established on. And indeed, I think any responsible interpreter, especially in the cold light of day, having 20/20 hindsight, would say that these acts were contrary to the First Amendment of the United States Constitution, which protects the freedom of speech and the freedom of the press. But at the time, supporters of President Adams, people who were members of the Federalist Party, thought that these laws were needed to protect the United States against subversion, either from within, by our own citizens whose sympathies ran against the government and possibly toward foreign powers, or from without, aliens who were in the United States but whose loyalties weren't to the United States.
Whereas the Alien Act targeted foreigners, the Sedition Act targeted U.S. citizens. The Sedition Act made it a crime for American citizens to write, say, or print anything false, scandalous, and malicious about the government, the Congress, or the President.
It was probably, I mean, a lot of people felt an out-and-out violation of the First Amendment because it curtailed both freedom of speech and freedom to print criticisms.
So this is the early toddling stages of American political discourse. And at this point, they hadn't gotten the idea that you could have a robust and legitimate criticism of the government without endangering the government with anarchy or civil war.
Now, President Jefferson, future President Jefferson, Thomas Jefferson, and the Republicans, who were the primary opponents of the Federalists in those days, loathed the Alien and Sedition Acts. They thought they were an outrage and an abomination and a violation of the Constitution of the United States. But of course, they weren't in power yet, and so during Adams' administration, the Alien and Sedition Acts were passed and applied.
There were about 15 indictments brought in the federal courts for violation of the Sedition Act. Remember, this was the one that said you couldn't criticize the government. And so they singled out certain of these prominent editors, and the federal government did indict them for a violation of this act. There were, I think, 10 convictions, and some people actually went to jail. Matthew Lyons was a famous case up in Vermont. He spent, 4 months in jail for what we would consider today, I think, fairly modest criticism of President Adams.
Americans were furious with the Federalists because the Alien and Sedition Acts threatened freedom of the press and freedom of speech, two rights guaranteed by the Constitution.
And here, in 1798, Congress exercises this huge power, suppressing freedom of speech, curtailing party development, and so on. So the real question was a constitutional one. Could Congress do this according to the Constitution? Well, hey, the Federalist parties obviously said yes, they could. The Virginia and Kentucky resolutions were the response of the emerging Democratic Republican Party, and especially in Virginia, and especially, of course, the authors of those two resolutions were Jefferson and Madison.
Those were resolutions by which some leading statesmen, including Jefferson, attempted to establish a right of the states to nullify federal acts that the states believed to be unconstitutional, like the Alien and Sedition Acts.
And the argument put forth were really pretty radical, especially Jefferson's Kentucky resolution. He basically argued that the power of Congress is curtailed to the very bare necessities, a very specific limit on the powers of Congress, a strict interpretation, I guess one might call it, of the enumerated powers in Article 1, Section 8 of the Constitution. Interestingly enough, because it is kind of prophecy, I mean, the resolutions rely very heavily on the 10th Amendment. The 10th Amendment is the amendment which reserves powers to the states and to the people unless they're specifically prohibited by the Constitution. So already what we've got here is a states' rights argument, states' rights constitutional argument. Now, he didn't say how the states are going to resist, but he did say that, sovereignty belongs to the states. The national government is an agent of the states. And in cases of constitutional disputes over the extent of national power, it's up to the states. I mean, this sounds like John C. Calhoun. And as a matter of fact, when John C. Calhoun wrote his exposition and protest, 1828, he relied on and defended his ideas by reference to the spirit of 98. What's he talking about is the Virginia-Kentucky resolutions.
Eventually, protests led to the repeal of the acts and also contributed to the defeat of the Federalists in the election of 1800.
And by the way, it was the theory on which the southern states finally seceded from the Union in 1861. So we're talking here not just, abstract theory, but ideas that people will ultimately act on in American history.
The Alien and Sedition Acts tested the limits of our First Amendment freedoms and demonstrated the strength of the Constitution to weather these types of assaults. On the eve of the election of 1800, the Democratic-Republican Party was determined to win the presidency and put its hopes in Thomas Jefferson to give them the victory. The election of 1800 presented yet another electoral crisis. Democratic Republicans Thomas Jefferson and Aaron Burr ran against Federalists John Adams and Charles Pinckney for president. In elections back then, although parties placed two names on a ticket, they never specified which candidate was running for president and which for vice president. In 1800, Thomas Jefferson and Aaron Burr, two candidates from the same party, received the same number of votes. To prevent this problem from ever happening again, Congress proposed the 12th Amendment to the Constitution. Ratified in 1804, the amendment included a number of remedies. The most effective was that it required electors to use separate ballots in voting for president and vice president. In 1803, the first case in which the Supreme Court established the right of judicial review was Marbury versus Madison. But first, some background. After the election of 1800, hostility and distrust between the Federalists and Democratic Republicans deepened. Federalists feared that everything they accomplished during the previous 4 years would be overturned by the incoming Democratic-Republican administration. To prevent this from happening, the Federalists quickly passed laws and created new circuit courts and federal judgeships, which John Adams spent the last days in office filling with Federalist appointees.
One of the things they did was pass what they called the Judiciary Act of 1801. The Judiciary Act of 1801 created a whole new set of federal courts, federal circuit courts, and a whole new set of judges to occupy positions, 16 new circuit court judges. And of course, John Adams had the right to appoint these judges. These were last-minute these were, in a sense, the judges that are sometimes called the midnight judges.
One of the vacancies that Adams has to fill in 1800 is the Chief Justiceship of the United States. The story goes that Adams is talking to his Secretary of State, who at that time is John Marshall, and says to Marshall, "Who should I nominate?" And Marshall is standing in front of Adams' desk, says nothing, and Adams looks to him and says, "I shall nominate you." And John Marshall becomes nominated to be the 4th Chief Justice of the United States.
Okay, I did consider the themes of this period in this book that I wrote. It's called John Marshall and the Heroic Age of the Supreme Court. One of the several themes in the book that sort of unify the book was this ongoing argument between John Marshall and Thomas Jefferson. So here are these two guys who now are ideological enemies. One of them, Jefferson, the states' rights guy. Marshall, the constitutional nationalist. Marshall is now Chief Justice of the United States. Jefferson is President of the United States. The great case of Marbury versus Madison was, in the ultimate sense, not just a struggle over legal doctrine, but a struggle over politics and ideology. And it's reflected by those two people.
Undeniably, any constitutional scholar will tell you the greatest of all is John Marshall. And Adams, upon leaving the White House, classified Marshall as his gift to the American public.
Judicial review is the power given to the courts to declare an act of any other governmental actor unconstitutional.
So the genius of Marshall sets the court on the course of allowing itself to interpret law and to negate law, to claim that acts of Congress or acts of the legislature or acts of any other governmental actor can be null and void if they violate the Constitution.
Well, we all agree, or most constitutional commentators agree, that Marbury against Madison did create the power of judicial review, or the court created the power of judicial review in the Marbury against Madison case. But we have a big disagreement to this very day about what the scope of that power is. Can the Supreme Court rule any statute to be unconstitutional? Can the Supreme Court override the contrary constitutional judgment of a president? Can the Supreme Court invalidate the acts of the United States government in the field of foreign affairs, or is it strictly limited to the domestic realm? So we have a range of questions on which people disagree, and part of that disagreement is a disagreement about just how broad the scope of judicial review established under Marbury against Madison actually is.
It's interesting to note that the Constitution does not specifically spell out the power granted the Supreme Court. Before Marbury, the judicial branch was weaker than the executive and legislative branches of government. Marbury leveled the playing field, giving the Supreme Court the power to invalidate any law that, in the court's opinion, violated the Constitution. The background of the case was this. William Marbury was among the many appointees John Adams had given judicial positions to on the eve of his leaving office. When Jefferson came into power, he ordered the Secretary of State, James Madison, not to grant Marbury his appointment. Marbury, in turn, filed suit, asking the Supreme Court to issue a court order requiring Madison to deliver his commission.
It was Jefferson who refused to deliver these commissions. And Marshall argued that he was obliged by statute law in the performance, or his Secretary of State, Madison, but back of Madison was Jefferson, that Madison was obliged by federal statute. He had no discretion. This was law. He had to deliver the commissions. Not to deliver them would be a violation of the law. What Marshall does in the middle of this opinion is give the President of the United States a lecture on the rule of law. It was pretty audacious. I mean, it was tremendously gutsy, controversial thing to do, as you might very well imagine.
Marbury versus Madison is the case in which the court breathes life into the institution of the judiciary, and John Marshall finds a clever way to tell Madison that he's wrong and makes him do nothing about it, which is the genius of John Marshall.
Marshall's decision established the Supreme Court's power of judicial review and recognized the Supreme Court as the ultimate interpreter of the Constitution. Any law written by the legislature and any order issued by the executive branch that conflicted with the Constitution would be deemed null and void.
The mentions of the judiciary in the Constitution are rather brief. Article 3 is of the three major articles that create the institutions of government, is by far the shortest. It is vague. Federalist 78, which points to the court and its role, is the most clear of all the Federalist Papers about the judicial branch. But still the role of the judiciary initially is not clear, and it's Marshall in his 34 years as Chief Justice who puts his stamp and shapes the judicial branch. There's a wonderful quote from Marbury versus Madison in which Marshall says, "It is emphatically the province and duty of the judicial department to say what the law is." And it's the court who sees their role as defining and interpreting the Constitution and what law means.
One of the largest land deals ever negotiated happened in 1803, when the United States purchased the Louisiana Territory from France. In 1803, the size of the United States and its territories was a fraction of what it is today. Most of the land was unexplored wilderness, and some of it was claimed by other nations. One of Thomas Jefferson's goals upon taking office was to expand the size of the United States. His plan was designed to prevent problems with European nations that owned these territories, to protect our borders from foreign aggressors, to secure the exclusive rights to navigate the western waters, and to develop the fertile western regions.
One of the most interesting things about it was that Thomas Jefferson was a strict constructionist of the Constitution. He believed that the federal government, in exercising its powers, really was strictly limited to the powers delegated to the government by the Constitution. And of course, there was no constitutionally delegated power to acquire new property by purchase. So Jefferson, as a strict constructionist, was in a bit of a dilemma. He knew that what he had on offer from Napoleon was an extraordinarily good deal, a very small amount of money for a vast amount of acreage, something that would be very important and useful to the United States of America. On the other hand, he didn't really believe that he, as the head of the federal government, as the head of the executive branch of the federal government, had a right under the Constitution to consummate the purchase.
The Louisiana Purchase is an enormously important turning point in the history of the United States. In the first case, it's completely unprecedented in constitutional law. The Founding Fathers had made no provision for the possibility that someone would want to sell America half a continent.
The Louisiana Territory was an area as large as Great Britain, France, Germany, Italy, Spain, and Portugal combined. With the Louisiana Purchase, 13 states would eventually be added to the nation.
Certainly the Louisiana Purchase was a decisive moment in the history of the United States, if for no other reason, because it expanded the United States so profoundly. It doubled the size of the United States.
Later on, 20 or 30 years later, when sectional issues between the North and the South become more and more important, people talk about a right to secession. But although it may plausibly be argued that the 13 original colonies voluntarily created a compact and that they have the right to withdraw from it, it's very hard to see how something you buy can possibly withdraw from the contract. Imagine if I were to buy a house and then it were to secede from me. Do I still have to pay the mortgage?
The Louisiana Purchase Treaty was, for President Jefferson, a political triumph. It ended the threat of war with France and opened up the land west of the Mississippi to settlement. By any measure, the purchase of the Louisiana Territory was the most important action of Jefferson's 2 terms as president.
I think he was never convinced that he had done the right thing constitutionally, but he did think that it was the right thing to do for the country, so he was willing to engage in what he considered a constitutional violation in order to achieve a larger public end. I don't think we would want our presidents to do that very often, but I think the judgment of history is probably that he did the right thing in that case.
Besides wading through a series of domestic conflicts, America had to contend with foreign encroachment as well, especially from Great Britain. In 1812, this led President James Madison to ask Congress to confirm his declaration of war against England. Thomas Jefferson, who wanted to maintain our nation's policy of neutrality, attempted to quiet Great Britain by urging Congress to pass several economic sanctions. Not only did the sanctions fail to stop Britain, they placed a toll on Americans whose livelihoods depended on foreign trade. The problem with Britain persisted throughout Thomas Jefferson's presidency and into his successor's James Madison. Americans grew impatient. In 1810, a new Congress was elected. Among the new members were war hawks like Henry Clay of Kentucky and John C. Calhoun of South Carolina. Finally, in 1812, the United States had enough. President Madison asked for a declaration of war.
I should say, perhaps as background to that there was a first bank in the United States. This was Hamilton's Bank, chartered in 1791. The charter expired in 1811, so we, in a sense, waged the War of 1812 without the benefit of a central bank, and it proved to be fairly disastrous.
During the first few months of the war, the United States ground troops suffered defeat, whereas the Navy, with its powerful ships, was victorious at sea and on the Great Lakes. On August 24, 1814, the British attacked Washington and overwhelmed the American forces. The British captured the city and set fire to many public buildings, including the White House. The most decisive American victory took place in Louisiana at the Battle of New Orleans. Capturing New Orleans would give the British a foothold on our soil and a port of entry into the interior of the continent.
This, incidentally, is the battle which projects Andrew Jackson into national prominence, and it's going to be the beginning of his great political career during the first part of the 19th century.
On December 24, 1814, after months of peace negotiations, the war officially came to an end when U.S. and British representatives signed the Treaty of Ghent in Belgium. However, news of the signing did not reach American shores until after General Jackson led the decisive victory in New Orleans, a victory that was thought to have brought the war to a close.
It took quite a long time for news of the treaty and the conclusion of the war to travel across the vast Atlantic Ocean. In the meantime, the forces of the British and the Americans engaged each other in a bloody battle, the Battle of New Orleans, and many lives were lost, lives that were lost needlessly since the war had already ended.
The War of 1812 was a turning point for the United States. The victory in New Orleans forced the British to recognize the United States claims to Louisiana and West Florida. It reinforced America's independence from England, and it marked the beginning of a long and peaceful partnership with England that continues today. In other programs in this series, we'll review the treaties, laws, landmark court decisions, and similar milestones that have shaped America's destiny. Documents of Destiny.